Question 1. The investigation demonstrates that a director of an Alabama-based publicly traded company, who also holds a substantial personal investment in a key supplier, participated in board discussions and voted on a contract renewal with that supplier. The director asserted that they believed the terms were fair and beneficial to the company. Which of the following approaches best reflects professional best practice in managing this conflict of interest under Alabama corporate governance principles? Option A. The director abstained from voting on the contract renewal, but remained actively involved in board discussions regarding the supplier's performance and the contract terms, believing their insights were valuable. Option B. The director disclosed their personal investment to the board and voted in favor of the contract renewal, relying on their personal assessment that the terms were fair and in the company's best interest. Option C. Director fully disclosed their personal investment to the board, recused themselves from all discussions and voting concerning the supplier contract, and the board, with independent advice, approved the contract based on its demonstrable fairness to the company. Option D. The director personally negotiated the terms of the contract renewal with the supplier, ensuring they believed the terms were favorable, and then presented the finalized contract to the board for ratification. The correct answer is C. The director fully disclosed their personal investment to the board, recused themselves from all discussions and voting concerning the supplier contract, and the board, with independent advice, approved the contract based on its demonstrable fairness to the company. Explanation. The investigation demonstrates a scenario where a publicly traded company in Alabama faces a potential conflict of interest involving a director who also holds a significant stake in a supplier. This situation is professionally challenging because it requires a delicate balance between the director's fiduciary duties to the corporation and their personal financial interests. The Alabama Business Corporation Act and general principles of corporate governance demand that directors act in the best interests of the corporation and its shareholders, avoiding self-dealing and ensuring transparency. Careful judgment is required to navigate the complexities of disclosure, recusal, and fair dealing to maintain shareholder trust and regulatory compliance. The best professional practice involves a comprehensive approach to managing the conflict. This includes full disclosure of the director's interest to the board, recusal from any discussions or votes directly related to the supplier contract, and ensuring the contract terms are demonstrably fair and at arm's length, potentially through independent board committee review. This approach aligns with Alabama's corporate law principles emphasizing good faith, loyalty, and the duty of care, as well as broader ethical standards that mandate avoiding situations where personal interests could compromise corporate decision-making. An approach that involves the director abstaining from voting, but remaining involved in discussions without full board disclosure of their personal stake is professionally unacceptable. This fails to meet the transparency requirements inherent in fiduciary duties, as other board members may not fully appreciate the potential influence of the director's personal interest. Furthermore, a scenario where the director negotiates the contract directly, even with the intention of securing favorable terms, presents a significant risk of self-dealing and a breach of the duty of loyalty, as their personal gain could inadvertently outweigh the corporation's best interests. Relying solely on the director's assurance of fairness without independent verification or board oversight also falls short of best practices and exposes the corporation to regulatory scrutiny and potential litigation. Professionals should employ a decision-making framework that prioritizes transparency, independent oversight, and adherence to fiduciary duties. When a potential conflict of interest arises, the first step should always be full and frank disclosure to the board. Subsequently, the board should collectively determine the appropriate course of action, which may include recusal, independent review, or seeking external legal counsel, to ensure that all decisions are made in the best interests of the corporation and its shareholders, free from undue personal influence. Question 2. Analysis of a publicly traded corporation operating in Alabama, Greenleaf Energy, which is facing pressure from investors to increase short-term profits. The company's current operations, while legally compliant with Alabama environmental regulations, have a discernible negative impact on local water quality. The CEO is considering several approaches to address this situation. Which approach best aligns with corporate social responsibility and ethical best practices in Alabama? Option A. Continue current operations, arguing that legal compliance is sufficient and that any additional investment would detract from shareholder returns, while making minor, cosmetic changes to public relations materials to suggest environmental concern. Option B. Publicly announce a commitment to improving water quality, but allocate minimal resources to actual implementation, focusing instead on marketing campaigns that highlight the company's supposed environmental efforts. Option C. Lobby the Alabama legislature to relax existing water quality regulations, thereby reducing the company's compliance costs and operational burdens. Option D. Proactively invest in advanced water treatment technologies that exceed current regulatory requirements. Transparently communicate these investments and their environmental benefits to stakeholders, and integrate water stewardship into the company's long-term strategic planning. The correct answer is D. Proactively invest in advanced water treatment technologies that exceed current regulatory requirements. Transparently communicate these investments and their environmental benefits to stakeholders, and integrate water stewardship into the company's long-term strategic planning. Explanation. This scenario presents a professional challenge due to the inherent tension between maximizing shareholder value, a traditional corporate finance objective, and the growing imperative for corporations to consider their broader societal and environmental impact. The company's leadership must navigate the ethical considerations of its operational decisions and their consequences, balancing legal compliance with stakeholder expectations and corporate social responsibility (CSR) principles. Careful judgment is required to ensure that decisions are not only profitable, but also ethically sound and sustainable in the long term, aligning with the evolving regulatory and public perception landscape in Alabama. The best professional practice involves proactively integrating CSR principles into the company's core business strategy and decision-making processes, ensuring transparency and accountability in all operations. This approach recognizes that genuine CSR extends beyond mere compliance and involves a commitment to ethical conduct, environmental stewardship, and positive social impact. In Alabama, while specific CSR mandates may be less prescriptive than in some other jurisdictions, the general principles of corporate good faith, fiduciary duty, and adherence to ethical business practices are paramount. This proactive integration ensures that the company's actions are aligned with its stated values and contribute positively to the community and environment, thereby mitigating reputational risk and fostering long-term stakeholder trust. An approach that prioritizes short-term profit maximization without adequate consideration for environmental impact is professionally unacceptable. This failure stems from a narrow interpretation of fiduciary duty, neglecting the broader ethical and legal implications of environmental degradation. Such actions could expose the company to significant regulatory penalties under Alabama environmental laws, potential litigation from affected parties, and severe damage to its reputation, ultimately undermining long-term shareholder value. Another professionally unacceptable approach is to engage in superficial greenwashing, or token CSR initiatives that lack genuine commitment or measurable impact. This misrepresents the company's environmental and social performance to stakeholders, violating ethical principles of honesty and transparency. While it may appear to address CSR concerns superficially, it fails to meet the substantive expectations of ethical corporate behavior and can lead to accusations of deception, eroding trust, and potentially inviting regulatory scrutiny for misleading practices. Finally, an approach that solely relies on legal minimums for environmental and social practices, without striving for best practices or considering the evolving expectations of stakeholders, is also professionally deficient. While legally compliant, this approach demonstrates a lack of ethical foresight and a failure to embrace the spirit of corporate responsibility. It leaves the company vulnerable to future regulatory changes, public backlash, and competitive disadvantages as more socially responsible competitors gain favor. Professionals should employ a decision-making framework that begins with a thorough understanding of all relevant legal and regulatory requirements in Alabama. This should be followed by an assessment of the ethical implications of each potential decision, considering the impact on all stakeholders, including employees, customers, the community, and the environment. A commitment to transparency, accountability, and continuous improvement in CSR performance should guide the selection of the most responsible and sustainable course of action, even if it involves short-term costs. Question 3. Consider a scenario where a publicly traded technology company headquartered in Alabama is seeking to acquire a smaller, privately held software firm also operating within Alabama. The acquiring company's management believes the acquisition will streamline operations and expand its product offerings. What is the most prudent approach to ensure compliance with Alabama's corporate finance law, specifically concerning regulatory approvals and potential antitrust considerations? Option A. Focus primarily on the financial synergies and operational efficiencies of the proposed acquisition, believing that these benefits will outweigh any potential regulatory hurdles related to competition. Option B. Rely on informal discussions with legal counsel regarding the general antitrust landscape without undertaking a specific, documented analysis of the proposed transaction's competitive effects within Alabama. Option C. Assume that because the target company is privately held and smaller than the acquirer, the transaction will not raise significant antitrust issues under Alabama law, and proceed with the acquisition without a formal antitrust assessment. Option D. Conduct a comprehensive antitrust review to assess the potential impact of the acquisition on market concentration, competitive landscape, and consumer welfare within Alabama, and proactively develop strategies to mitigate any identified antitrust concerns before seeking regulatory approval. The correct answer is D. Conduct a comprehensive antitrust review to assess the potential impact of the acquisition on market concentration, competitive landscape, and consumer welfare within Alabama, and proactively develop strategies to mitigate any identified antitrust concerns before seeking regulatory approval. Explanation. This scenario presents a professional challenge due to the inherent tension between a company's desire to expand its market presence and the Alabama corporate finance law's mandate to prevent anti-competitive practices that could harm consumers or other businesses. Navigating the regulatory approval process requires a thorough understanding of antitrust principles and a proactive approach to compliance. The complexity arises from identifying potential antitrust issues early and addressing them effectively before they jeopardize the transaction. The best professional approach involves conducting a comprehensive antitrust review that goes beyond a superficial check. This includes analyzing the proposed transaction's potential impact on market concentration, the likelihood of reduced competition, and the potential for price increases or diminished product quality for Alabama consumers. This approach is correct because it aligns directly with the spirit and letter of Alabama's antitrust laws, which aim to foster a competitive marketplace. By proactively identifying and mitigating potential antitrust concerns, the company demonstrates a commitment to regulatory compliance and ethical business conduct, thereby increasing the likelihood of successful approval and avoiding future legal entanglements. This thoroughness is crucial for demonstrating good faith to the Alabama Attorney General's office or other relevant regulatory bodies. An incorrect approach would be to assume that because the transaction is a merger of two relatively small companies, it will automatically escape antitrust scrutiny. This overlooks the cumulative effect of market consolidation and the potential for even smaller players to collectively stifle competition. Such an assumption risks violating Alabama's antitrust statutes by failing to adequately assess the transaction's competitive impact. Another incorrect approach is to focus solely on the financial and operational benefits of the merger without adequately considering the regulatory landscape. While financial viability is important, it does not supersede the legal requirement to ensure that the transaction does not harm competition. This narrow focus can lead to overlooking critical antitrust red flags, potentially resulting in regulatory rejection or significant post-merger penalties. Finally, an approach that relies on informal assurances from legal counsel without a formal, documented antitrust analysis is also professionally unsound. While counsel's advice is valuable, a robust antitrust review requires a structured process that systematically evaluates potential issues and develops mitigation strategies. Relying on informal discussions can lead to a false sense of security and an incomplete understanding of the regulatory risks. Professionals should adopt a decision-making framework that prioritizes proactive compliance and thorough due diligence. This involves engaging antitrust counsel early in the process, conducting detailed market analysis, and developing a clear strategy for addressing any identified antitrust concerns before submitting for regulatory approval. The goal is to demonstrate to regulators that the transaction will not unduly harm competition within Alabama. Question 4. During the evaluation of a proposed private placement of securities by an Alabama-based technology startup, which is seeking to raise capital from its founders and early employees, all of whom are residents of Alabama, what is the most prudent course of action to ensure compliance with Alabama corporate finance law? Option A. Initiate the full registration process with the Alabama Securities Commission, as this is the safest approach for any securities offering. Option B. Proceed with the offering, assuming that because the company is incorporated in Alabama and all investors are Alabama residents, the offering is automatically exempt from registration. Option C. Investigate federal exemptions like Regulation D, assuming that compliance with federal securities laws will automatically satisfy Alabama's requirements. Option D. Thoroughly research and apply the Alabama Interstate Offering Exemption, confirming all statutory and rule-based requirements are met, including issuer and investor residency, and the intended use of proceeds within Alabama. The correct answer is D. Thoroughly research and apply the Alabama Interstate Offering Exemption, confirming all statutory and rule-based requirements are met, including issuer and investor residency, and the intended use of proceeds within Alabama. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires a nuanced understanding of Alabama securities law, specifically the exemptions available for intrastate offerings. The firm must balance the desire to raise capital efficiently with the absolute necessity of complying with state regulations to avoid severe penalties, including rescission rights for investors and potential enforcement actions by the Alabama Securities Commission. Misinterpreting or misapplying exemption criteria can lead to significant legal and financial repercussions. Correct approach analysis. The best professional practice involves a thorough review of the Alabama Securities Act and its associated rules to determine if the proposed offering qualifies for an exemption. Specifically, the professional should investigate the Alabama Intrastate Offering Exemption, often found under Section 8-6-11A. 11 of the Alabama Code, or similar provisions and administrative rules. This requires confirming that the issuer is a resident of Alabama, all sales are made only to residents of Alabama, and that no part of the offering proceeds will be used outside of Alabama. If these criteria are met, the offering can proceed without registration, provided any required filings, such as a notice filing, are made. This approach is correct because it directly addresses the regulatory requirements for securities offerings within Alabama and seeks to utilize a specific, legally recognized exemption. Incorrect approach is analysis. One incorrect approach is to assume that because the company is incorporated in Alabama and the investors are also residents of Alabama, the offering is automatically exempt from registration. This fails to consider the full scope of the intrastate exemption, which often includes additional conditions such as the issuer's principal place of business being in Alabama and the proceeds being used within the state. Simply meeting 2 out of 3 criteria is insufficient. Another incorrect approach is to proceed with the offering without any inquiry into exemptions, assuming that all securities offerings require registration with the Alabama Securities Commission. While registration is the default, failing to explore available exemptions means the firm may be undertaking unnecessary and costly registration processes, potentially hindering capital formation. More importantly, if an exemption asterisk is asterisk available and not utilized, it's a missed opportunity for efficient compliance. A third incorrect approach is to rely on general knowledge of federal securities law exemptions, such as Regulation D, without verifying their applicability or any state-specific blue sky law conformity requirements in Alabama. While federal exemptions may be available, Alabama law still requires compliance with state registration or exemption provisions. A federal exemption does not automatically exempt an offering from state securities laws. Professional reasoning. Professionals in Alabama must adopt a proactive and diligent approach to securities offerings. This involves first identifying the relevant state securities laws, the Alabama Securities Act. Then, they must determine whether the proposed offering requires registration or if an exemption is available. If an exemption is being considered, the professional must meticulously analyze all conditions and requirements of that specific exemption under Alabama law. This includes verifying issuer and investor residency, the use of proceeds, and any necessary notice filings or reporting requirements. If no exemption applies, the professional must then guide the client through the registration process in compliance with Alabama's regulatory framework. This systematic, jurisdiction-specific approach ensures compliance and protects both the client and the professional from legal jeopardy. Question 5. Research into the capital-raising activities of an Alabama-based technology startup reveals that the company has experienced significant operational challenges in its early stages, including product development delays and a key executive's departure. While the company is now projecting strong future growth based on a new market strategy, the disclosure document prepared for potential investors focuses exclusively on these optimistic projections and omits any mention of the past difficulties. Under Alabama corporate finance law, what is the most appropriate professional response to this situation? Option A. Focus the disclosure solely on the company's current market strategy and its potential for success, arguing that past issues are no longer relevant to future investment decisions. Option B. Include a general disclaimer stating that the company's past performance is not indicative of future results, without detailing the specific challenges faced. Option C. Revise the disclosure document to include a clear and comprehensive discussion of the past operational challenges, their potential impact on future performance, and the specific steps being taken to mitigate these risks, alongside the positive growth projections. Option D. Proceed with the current disclosure document, assuming that sophisticated investors will conduct their own due diligence and uncover any past issues. The correct answer is C. Revise the disclosure document to include a clear and comprehensive discussion of the past operational challenges, their potential impact on future performance, and the specific steps being taken to mitigate these risks, alongside the positive growth projections. Explanation. This scenario presents a professional challenge because it requires a nuanced understanding of Alabama corporate finance law, specifically regarding the disclosure obligations when a company is seeking to raise capital. The challenge lies in balancing the need to attract investors with the legal and ethical imperative to provide accurate and complete information, thereby preventing potential misrepresentation or omission of material facts. Careful judgment is required to discern what constitutes material information that must be disclosed under Alabama law. The best professional approach involves a thorough review of the company's financial health and operational risks, followed by the preparation of a disclosure document that clearly and comprehensively outlines all significant information relevant to an investor's decision. This includes not only positive aspects, but also any potential risks, liabilities, or uncertainties that could impact the company's future performance. This approach aligns with the principles of full and fair disclosure mandated by Alabama corporate finance regulations, which aim to protect investors by ensuring they have access to all material information necessary to make informed investment decisions. Adhering to these principles prevents deceptive practices and fosters trust in the capital markets. An approach that focuses solely on highlighting the company's strengths and positive projection, while downplaying or omitting any negative aspects or potential risks, is professionally unacceptable. This constitutes a failure to provide full and fair disclosure, which is a direct violation of Alabama corporate finance laws. Such omissions can mislead investors into making decisions based on incomplete or inaccurate information, potentially leading to financial losses and legal repercussions for the company and its officers. Another professionally unacceptable approach is to rely on vague or generalized statements about risks without providing specific details or context. While acknowledging risks is a step towards disclosure, failing to elaborate on their nature, likelihood, and potential impact renders the disclosure insufficient and potentially misleading. This approach circumvents the spirit of the law, which requires transparency regarding material risks. Finally, an approach that assumes investors will conduct their own due diligence and therefore absolves the company of the responsibility to disclose all material information is also flawed. While due diligence is a part of the investment process, the primary responsibility for providing accurate and complete information rests with the company seeking to raise capital. Relying on the investor's independent investigation does not negate the company's legal obligation to disclose all material facts upfront. Professionals should employ a decision-making framework that prioritizes legal compliance and ethical conduct. This involves 1. Identifying all potentially material information, both positive and negative. 2. Assessing the materiality of each piece of information from an investor's perspective. 3. Drafting disclosures that are clear, concise, and unambiguous, avoiding jargon or misleading language. 4. Seeking legal counsel to ensure compliance with all applicable Alabama corporate finance laws and regulations. 5. Regularly reviewing and updating disclosures as circumstances change. Question 6. The risk matrix shows a potential conflict of interest for a financial advisor in Alabama who is recommending an investment product offered by a third-party vendor with whom the advisor's firm has a referral fee arrangement. The advisor is aware of this arrangement, which provides a commission to their firm for each successful referral. What is the most appropriate course of action for the advisor to take to ensure compliance with Alabama corporate finance law and ethical standards? Option A. Verbally inform the client about the referral fee arrangement during the meeting where the recommendation is made, assuming the client will understand the implications. Option B. Disclose the referral fee arrangement to the client only after they have agreed to invest in the product. Option C. Proceed with the recommendation without disclosing the referral fee arrangement, believing the investment is in the client's best interest and the arrangement is a standard business practice. Option D. Provide the client with a detailed written disclosure of the referral fee arrangement, including the specific amount or percentage the firm receives, and explain how this arrangement might influence the recommendation, allowing the client to make an informed decision before proceeding. The correct answer is D. Provide the client with a detailed written disclosure of the referral fee arrangement, including the specific amount or percentage the firm receives, and explain how this arrangement might influence the recommendation, allowing the client to make an informed decision before proceeding. Explanation. The risk matrix shows a potential conflict of interest arising from a financial advisor's dual role. This scenario is professionally challenging because it requires navigating the complex ethical and regulatory landscape of financial advice in Alabama, specifically concerning disclosure and client best interests. The advisor must balance their firm's business objectives with their fiduciary duty to clients, ensuring transparency and avoiding any appearance of impropriety. Careful judgment is required to uphold the integrity of the advisory relationship and comply with Alabama securities laws. The best approach involves proactively identifying the conflict and implementing a robust disclosure process. This means clearly and comprehensively informing the client about the advisor's relationship with the third-party vendor, including any financial incentives or benefits received by the advisor or their firm. This disclosure must be made in writing and in a manner that the client can reasonably understand, allowing them to make an informed decision about whether to proceed with the recommended investment. This aligns with the principles of transparency and client protection mandated by Alabama's regulatory framework for financial professionals, which emphasizes the duty to act in the client's best interest and avoid conflicts of interest through adequate disclosure. An approach that involves only a verbal mention of the relationship during a meeting is professionally unacceptable. This fails to provide adequate documentation and assurance that the client fully comprehends the nature and implications of the conflict. Such a casual disclosure risks being overlooked or misunderstood, undermining the client's ability to make an informed decision and potentially violating Alabama's disclosure requirements. Another professionally unacceptable approach is to proceed with the recommendation without any disclosure, assuming the client will benefit from the investment. This directly contravenes the ethical obligation to avoid conflicts of interest and the regulatory requirement for transparency. It prioritizes the firm's potential gain or the advisor's incentive over the client's right to know about potential biases. Finally, an approach that involves disclosing the conflict only after the client has agreed to the investment is also unacceptable. Disclosure must precede the client's decision-making process to be effective. Delaying disclosure until after commitment deprives the client of the opportunity to consider the conflict when making their initial choice and can be seen as an attempt to obscure or minimize the significance of the conflict. Professionals should adopt a proactive and transparent decision-making process. This involves regularly reviewing client relationships for potential conflicts of interest, understanding the specific disclosure requirements under Alabama law, and prioritizing clear, written communication with clients about any identified conflicts. The guiding principle should always be to ensure the client's interests are paramount and that they are empowered to make informed decisions free from undue influence or undisclosed bias. Question: the risk matrix shows a potential conflict of interest for a financial advisor in Alabama who is recommending an investment product offered by a third-party vendor with whom the advisor's firm has a referral fee arrangement. The advisor is aware of this arrangement, which provides a commission to their firm for each successful referral. What is the most appropriate course of action for the advisor to take to ensure compliance with Alabama corporate finance law and ethical standards? Options. A. Provide the client with a detailed written disclosure of the referral fee arrangement, including the specific amount or percentage the firm receives, and explain how this arrangement might influence the recommendation, allowing the client to make an informed decision before proceeding. B. Verbally inform the client about the referral fee arrangement during the meeting where the recommendation is made, assuming the client will understand the implications. C. Proceed with the recommendation without disclosing the referral fee arrangement, believing the investment is in the client's best interest and the arrangement is a standard business practice. D. Disclose the referral fee arrangement to the client only after they have agreed to invest in the product. Question 7. Benchmark analysis indicates that a director of an Alabama-based technology firm, Innovate Solutions, Inc., has a significant personal investment in a startup company that is seeking to acquire a patent currently held by Innovate Solutions, Inc. The director believes that the acquisition, at the proposed price, would be beneficial for Innovate Solutions, Inc., as it would allow the company to focus on its core competencies. However, the director stands to gain substantially from the success of the startup company. What is the most appropriate course of action for this director under Alabama corporate finance law principles of corporate governance? Option A. Abstain from voting on the patent acquisition without disclosing their personal interest to the board of directors. Option B. Disclose their personal interest in the startup company to the board of directors and recuse themselves from all discussions and voting related to the proposed patent acquisition. Option C. Vote in favor of the patent acquisition, believing that their personal interest aligns with and will ultimately benefit the corporation. Option D. Vote in favor of the patent acquisition without disclosing their personal interest, as they believe the transaction is in the best interest of Innovate Solutions, Inc. The correct answer is B. Disclose their personal interest in the startup company to the board of directors and recuse themselves from all discussions and voting related to the proposed patent acquisition. Explanation. Benchmark analysis indicates that the scenario presents a significant professional challenge due to the inherent conflict between a director's fiduciary duty to the corporation and the potential for personal gain. The Alabama Business Corporation Act, specifically provisions related to director duties and conflicts of interest, requires directors to act in good faith and in a manner they reasonably believe to be in the best interests of the corporation. This includes a duty of loyalty, which mandates that directors avoid self-dealing and place the corporation's interests above their own. The challenge lies in navigating situations where a director's personal interests might align with or even supersede those of the company, demanding a rigorous application of corporate governance principles to ensure fairness and transparency. The approach that represents best professional practice involves the director promptly disclosing their personal interest in the proposed transaction to the board of directors. Following disclosure, the director should recuse themselves from any discussions and voting on the matter. This aligns with the Alabama Business Corporation Act's emphasis on informed decision-making by disinterested directors and the avoidance of undue influence. By disclosing their interest and abstaining from voting, the director upholds their duty of loyalty and ensures that the board's decision is made by those without a personal stake, thereby protecting the corporation's interests. This process fosters transparency and allows the remaining directors to exercise their independent judgment. An incorrect approach involves the director voting on the transaction without disclosing their personal interest. This directly violates the duty of loyalty and the spirit of the Alabama Business Corporation Act, which presumes that decisions made by directors with undisclosed conflicts of interest are not made in good faith or in the best interests of the corporation. Such an action can lead to the transaction being voidable and expose the director to personal liability for any harm caused to the corporation. Another incorrect approach is for the director to vote in favor of the transaction, believing their personal interest will somehow benefit the corporation. While the intention might seem positive, it fails to acknowledge the fundamental principle that directors must avoid situations where their personal interests could compromise their independent judgment. The Alabama Business Corporation Act requires a clear separation between personal gain and corporate decision-making, and this approach blurs that line, creating an unacceptable risk of self-dealing. A further incorrect approach is for the director to abstain from voting, but fail to disclose their personal interest to the board. While abstention might seem like a way to avoid a conflict, the lack of disclosure means the other directors are not aware of the potential bias influencing the situation. This prevents the board from fully assessing the transaction's fairness and can still lead to decisions that are not in the corporation's best interests, as the full context of potential conflicts is not understood. The professional decision-making process for similar situations should begin with a thorough identification of any potential conflicts of interest. Once identified, the director must consult the relevant provisions of the Alabama Business Corporation Act and the company's own corporate governance policies. The paramount principle is to prioritize the corporation's interests and act with utmost good faith and loyalty. This typically involves full disclosure of the interest and recusal from deliberation and voting, ensuring that corporate decisions are made by an impartial and informed board. Question 8. Benchmark analysis indicates that Apex Innovations, Inc., a publicly traded Alabama corporation, is exploring a significant strategic combination with Synergy Solutions, LLC, a privately held Alabama limited liability company. Apex Innovations, Inc. intends to acquire all of Synergy Solutions, LLC's assets and assume all of its liabilities. Following the transaction, Synergy Solutions, LLC will cease its operations and distribute its remaining assets to its members. Apex Innovations, Inc. will continue its existing business operations, integrating the acquired assets and personnel. Given these circumstances, what is the most appropriate legal characterization of this transaction under Alabama corporate finance law, and what are the primary implications for Apex Innovations, Inc.? Option A. This transaction is a reverse triangular merger, where a subsidiary of Apex Innovations, Inc. would merge with Synergy Solutions, LLC, with Synergy Solutions, LLC surviving as a subsidiary of Apex Innovations, Inc., requiring specific merger filings and shareholder approvals for both entities. Option B. This transaction should be classified as a statutory merger, necessitating a formal merger agreement, extensive shareholder votes from both entities, and specific filings with the Alabama Secretary of State, as if Synergy Solutions, LLC were being absorbed directly into Apex Innovations, Inc. Option C. This transaction is a stock acquisition, meaning Apex Innovations, Inc. would acquire the ownership interest of Synergy Solutions, LLC's members, which would then require a vote of Apex Innovations, Inc. as shareholders to approve the issuance of new stock to the members of Synergy Solutions, LLC. Option D. This transaction is best characterized as an asset acquisition, requiring Apex Innovations, Inc. to file appropriate documentation with the Alabama Secretary of State and ensure proper shareholder approval for the acquisition of significant assets, as per Alabama Business Corporation Act provisions. The correct answer is D. This transaction is best characterized as an asset acquisition, requiring Apex Innovations, Inc. to file appropriate documentation with the Alabama Secretary of State and ensure proper shareholder approval for the acquisition of significant assets, as per Alabama Business Corporation Act provisions. Explanation. This scenario presents a professional challenge due to the inherent complexities and potential conflicts of interest in advising a client on a significant corporate transaction. The need for careful judgment arises from the requirement to ensure the chosen merger structure aligns with the client's strategic objectives while strictly adhering to Alabama corporate finance law, particularly concerning the disclosure and approval processes for different transaction types. The potential for mischaracterizing the transaction to circumvent regulatory hurdles or shareholder approvals is a significant ethical and legal risk. The approach that represents best professional practice involves a thorough analysis of the client's stated goals and the underlying economic realities of the proposed transaction to determine the most appropriate legal structure under Alabama law. This includes identifying whether the transaction constitutes a statutory merger, a stock acquisition, or an asset acquisition, each with distinct legal implications for shareholder rights, creditor protection, and corporate governance. Specifically, if the transaction involves the absorption of one entity into another, a statutory merger is the most accurate classification. This classification mandates adherence to the specific notice, voting, and filing requirements outlined in the Alabama Business Corporation Act, ensuring transparency and proper shareholder consent. This approach is correct because it prioritizes legal accuracy and regulatory compliance, safeguarding the client from potential legal challenges, and ensuring the transaction is executed with the necessary corporate formalities. An incorrect approach would be to structure the transaction as a stock acquisition solely to avoid the potentially more stringent shareholder approval requirements of a statutory merger, even if the economic substance of the deal is effectively a merger. This is ethically problematic as it misrepresents the nature of the transaction to stakeholders and regulators, potentially violating disclosure obligations under Alabama law. Such a mischaracterization could lead to claims of securities fraud or breach of fiduciary duty if shareholders are not afforded the rights they would have in a statutory merger. Another incorrect approach would be to classify the transaction as a simple asset sale when it involves the assumption of all liabilities and the continuation of the target company's business operations under the acquiring entity's name. While asset sales have different procedural requirements, mislabeling a de facto merger as an asset sale can lead to piercing the corporate veil and holding the acquiring entity liable for the target's debts and obligations, contrary to the intended legal separation. This also circumvents the statutory protections afforded to shareholders in a merger. Finally, an incorrect approach would be to proceed with the transaction based on informal discussions and a superficial understanding of the deal structure without conducting a detailed legal analysis of Alabama's corporate law. This demonstrates a lack of due diligence and professional responsibility, increasing the risk of noncompliance with statutory requirements, which could invalidate the transaction or expose the client to significant legal and financial penalties. Professionals should employ a decision-making process that begins with a comprehensive understanding of the client's objectives, followed by a rigorous legal analysis of the transaction structure under the applicable state law. In this case, Alabama corporate finance law. This involves identifying the most accurate legal classification of the proposed transaction and then ensuring all statutory requirements for that classification are met. Ethical considerations, such as transparency and fairness to all stakeholders, must be integrated into this process, alongside a thorough risk assessment of each potential structural approach. Question 9. Compliance review shows that a publicly traded company incorporated in Alabama is preparing its annual report. The Finance Department has compiled various financial ratios, including a strong current ratio and a healthy return on equity, but also a deteriorating debt-to-equity ratio and declining profit margins. The CFO is considering how to present this information in the report's management discussion and analysis section. Which of the following approaches best reflects compliance with Alabama corporate finance law and professional ethical standards? Option A. Present a balanced discussion of all key financial ratios, including both positive and negative trends, providing context through industry comparisons and historical data, and using neutral language to describe performance. Option B. Focus exclusively on the positive financial ratios and omit any discussion of the deteriorating debt-to-equity ratio and declining profit margins to maintain a positive investor perception. Option C. Present all financial ratios with highly optimistic language, framing even the negative trends as temporary challenges that are being overcome without providing detailed comparative data. Option D. Emphasize the positive financial ratios, such as the current ratio and return on equity, while briefly mentioning the negative trends with minimal detail and without significant context. The correct answer is A. Present a balanced discussion of all key financial ratios, including both positive and negative trends, providing context through industry comparisons and historical data, and using neutral language to describe performance. Explanation. This scenario presents a professional challenge because it requires an understanding of how to interpret and apply financial ratios within the specific context of Alabama corporate finance law, particularly concerning disclosure and potential misrepresentation. The challenge lies in distinguishing between legitimate business performance analysis and actions that could be construed as misleading investors or stakeholders, even if not explicitly fraudulent. Careful judgment is required to ensure that the presentation of financial performance is both accurate and compliant with Alabama's regulatory expectations for corporate disclosures. The best professional approach involves a comprehensive review of all relevant financial ratios and performance metrics, considering their trends over time and in comparison to industry benchmarks, and then presenting this analysis in a manner that is transparent and avoids any implication of guaranteed future performance or exaggeration. This approach is correct because it aligns with the principles of fair disclosure and investor protection mandated by Alabama corporate finance law. By providing a balanced and contextualized view of financial health, it upholds the ethical obligation to present information truthfully and avoids any potential for misleading stakeholders about the company's true financial standing. This proactive and thorough review ensures that any discussions or reports on financial performance are grounded in factual data and presented with appropriate caveats. An approach that focuses solely on highlighting positive ratios while downplaying or omitting negative ones is professionally unacceptable. This selective presentation can create a misleading impression of the company's financial health, potentially violating Alabama's regulations against deceptive practices in financial reporting. Such an approach fails to provide a complete and accurate picture, thereby undermining investor confidence and trust. Another professionally unacceptable approach is to present ratios without any context or comparison, such as failing to benchmark against industry averages or historical performance. While the ratios themselves may be mathematically correct, their isolated presentation can be misleading. Alabama corporate finance law expects disclosures to be meaningful and informative, and without context, these metrics may not adequately inform stakeholders about the company's true performance relative to its peers or its own past. Finally, an approach that uses overly optimistic language to describe financial performance, even when supported by some positive ratios, can also be problematic. While not explicitly fraudulent, such language can inflate expectations and create a perception of success that is not fully supported by the underlying financial reality. This can lead to accusations of misrepresentation and a failure to adhere to the spirit of transparent financial communication expected under Alabama law. Professionals should employ a decision-making framework that prioritizes accuracy, completeness, and transparency in all financial reporting. This involves a critical assessment of all available data, a thorough understanding of the relevant regulatory landscape in Alabama, and a commitment to communicating financial information in a way that is both informative and ethically sound. The process should involve seeking external validation or expert opinions when dealing with complex financial interpretations to ensure compliance and best practice. Question 10. Which approach would be most appropriate for valuing a private technology company in Alabama for an acquisition, given that there are several publicly traded companies with similar business models and growth trajectories, but limited publicly available data on the target's precise future cash flows and recent comparable acquisition transactions? Option A. Comparable company analysis. Option B. A weighted average of all three approaches without specific justification for each weight. Option C. Precedent transactions analysis. Option D. Discounted cash flow (DCF) analysis. Correct answer is A. Comparable company analysis. Explanation: scenario analysis. This scenario presents a common challenge in corporate finance, valuing a private company for a potential acquisition. The professional challenge lies in selecting the most appropriate valuation methodology given the limited public information and the specific context of an acquisition. A flawed valuation can lead to overpayment, underpayment, or regulatory scrutiny, impacting the fiduciary duties of the acquiring company's board and management under Alabama law. Careful judgment is required to ensure the valuation is both robust and defensible. Correct approach analysis. The most appropriate approach in this scenario is comparable company analysis. This method involves identifying publicly traded companies with similar business models, size, growth prospects, and risk profiles to the target company. By analyzing the valuation multiples, e.g., enterprise value/revenue, enterprise value/EBITDA, of these comparable companies, one can derive a valuation range for the target. This approach is favored because it grounds the valuation in observable market data, reflecting how the public market currently values similar businesses. Alabama corporate finance law, while not prescribing specific valuation methods, emphasizes the need for valuations to be reasonable and based on sound financial principles, which comparable company analysis generally provides by leveraging market consensus. Incorrect approaches analysis. Discounted cash flow (DCF) analysis, while a theoretically sound valuation method, presents significant challenges in this specific scenario. The primary difficulty lies in the reliability of future cash flow projections for a private company with limited historical data and potentially less transparent financial reporting. Alabama law requires valuations to be supported by evidence. Overly speculative projections in a DCF can lead to an unreliable valuation and potential breaches of fiduciary duty if the acquisition price is based on such projections. The inherent subjectivity in forecasting discount rates and terminal values further amplifies this risk. Precedent transactions analysis, while also market-based, can be problematic here due to the potential for unique deal-specific factors influencing past transaction prices. If the precedent transactions involved strategic synergies, control premiums, or distressed sales that are not present in the current acquisition context, using those multiples could lead to a distorted valuation. Alabama law expects due diligence, an evaluation that reflects the current market and the specific circumstances of the proposed transaction, not just historical deal terms that may not be comparable. Professional reasoning. When valuing a private company for acquisition, professionals should prioritize methods that rely on observable market data and are less susceptible to subjective forecasting. A tiered approach is often best. Start with comparable company analysis to establish a market-based range. If sufficient comparable public companies exist, this provides a strong foundation. Then, consider precedent transactions for additional market context, carefully adjusting for differences. Finally, a DCF can be used as a supplementary tool, but its inputs must be rigorously scrutinized and supported by robust assumptions, especially for private entities. The ultimate goal is a valuation that is defensible, reflects current market conditions, and aligns with the fiduciary responsibilities under Alabama law. Question: which approach would be most appropriate for valuing a private technology company in Alabama for an acquisition? Given that there are several publicly traded companies with similar business models and growth trajectories, but limited publicly available data on the target's precise future cash flows and recent comparable acquisition transactions. Options: A. Comparable company analysis. B. Discounted cash flow (DCF) analysis. C. Precedent transactions analysis. D. A weighted average of all three approaches without specific justification for each way. Question 11. Investigation of a potential acquisition of an Alabama-based technology startup by a publicly traded company reveals significant pressure from the startup's founders to close the deal within a tight time frame. The startup's management has provided a substantial amount of financial data and projections, but has been reluctant to share detailed operational contracts and minutes from recent board meetings, citing confidentiality and the need to maintain momentum. The acquiring company's lead deal negotiator is concerned about the incomplete information, but is being urged by senior management to proceed quickly to secure the acquisition. What is the most prudent course of action for the acquiring company's deal team under Alabama corporate finance law? Option A. Proceed with the acquisition based on the provided financial data and projections, assuming the startup's management has acted in good faith, and address any potential issues discovered post-acquisition. Option B. Focus solely on the financial projections provided by the startup, as these are the primary indicators of future value, and defer the review of operational contracts and board minutes to a later stage. Option C. Conduct a thorough and independent review of all provided financial statements, projections, contracts, and corporate governance documents, and insist on access to all requested information, including board minutes, before proceeding with the acquisition. Option D. Delegate the entire due diligence process to the startup's existing legal counsel, trusting their assessment of the company's compliance and financial standing. The correct answer is C. Conduct a thorough and independent review of all provided financial statements, projections, contracts, and corporate governance documents, and insist on access to all requested information, including board minutes, before proceeding with the acquisition. Explanation: this scenario presents a professional challenge due to the inherent conflict between the desire to expedite a transaction and the absolute necessity of fulfilling due diligence obligations under Alabama corporate finance law. The pressure to close quickly can tempt individuals to cut corners, which is precisely what regulatory frameworks aim to prevent. Careful judgment is required to balance business objectives with legal and ethical responsibilities. The correct approach involves a comprehensive and systematic review of all relevant financial and legal documentation pertaining to the target company. This includes scrutinizing financial statements, contracts, corporate records, and any disclosures made by the issuer. The justification for this thoroughness lies in Alabama's commitment to investor protection and market integrity. Alabama corporate finance law mandates that issuers and their representatives conduct diligent inquiry to ensure the accuracy and completeness of information provided to potential investors. Failing to perform adequate due diligence can lead to misrepresentations, investor losses, and significant legal repercussions for all parties involved, including potential violations of Alabama securities statutes. An incorrect approach would be to rely solely on the representations made by the target company's management without independent verification. This fails to meet the standard of diligent inquiry required by Alabama law. The regulatory failure here is the abdication of responsibility to independently assess the veracity of claims, thereby exposing investors to undue risk. Another incorrect approach would be to focus only on the financial projections while neglecting to review the underlying operational agreements and corporate governance documents. This is flawed because financial health is intrinsically linked to operational stability and sound management practices, all of which are subject to scrutiny under Alabama's regulatory framework. Overlooking these aspects means failing to identify potential systemic risks that could impact the investment's viability. Finally, an incorrect approach would be to delegate the entire due diligence process to external counsel without active involvement and oversight from the transaction principals. While legal counsel is crucial, the ultimate responsibility for ensuring the adequacy of due diligence rests with the parties facilitating the transaction. Delegating without proper oversight can lead to a superficial review that misses critical red flags, violating the spirit and letter of Alabama's corporate finance regulations. Professionals should employ a decision-making framework that prioritizes a structured, evidence-based approach to due diligence. This involves establishing clear objectives for the review, identifying key risk areas, and allocating sufficient resources to thoroughly investigate each aspect. Regular communication and collaboration among all involved parties, including legal, financial, and operational experts, are essential to ensure a holistic and effective due diligence process that aligns with Alabama's regulatory expectations. Question 12. Following the recent acquisition of a privately held Alabama-based technology firm by a publicly traded Alabama corporation, the integration team is tasked with merging operational systems and employee benefits. During a preliminary meeting, a senior executive from the acquiring company suggests that only the core integration team be privy to the target company's detailed financial projections for the next 3 years, citing the need for speed and to avoid unnecessary noise among other employees. The acquiring company's stock is listed on a national exchange, but its primary operations and incorporation are in Alabama. What is the most appropriate course of action for the integration team to ensure compliance with Alabama corporate finance law during this post-merger integration phase? Option A. Distribute the financial projections to a broader group of employees involved in operational integration, believing that wider internal awareness will facilitate a smoother transition, and rely on existing company policies for general confidentiality. Option B. Develop and implement a clear, documented policy for the handling and dissemination of all material non-public information related to the target company, ensuring all integration team members receive training on their obligations under Alabama securities laws, and that any required disclosures to the Alabama Securities Commission or the public are made promptly. Option C. Immediately halt all integration activities until a comprehensive legal review of all potential information sharing scenarios can be completed, even if this significantly delays the realization of merger synergies. Option D. Proceed with sharing the target company's financial projections with the core integration team as suggested, assuming that this information is for internal strategic planning and not subject to Alabama's disclosure requirements until a formal public offering or significant corporate action occurs. The correct answer is B. Develop and implement a clear, documented policy for the handling and dissemination of all material non-public information related to the target company, ensuring all integration team members receive training on their obligations under Alabama securities laws, and that any required disclosures to the Alabama Securities Commission or the public are made promptly. Explanation. This scenario presents a significant professional challenge due to the inherent complexities and potential conflicts arising during post-merger integration, particularly concerning the handling of sensitive information and the need for clear communication under Alabama corporate finance law. The pressure to quickly realize synergies and integrate operations can lead to rushed decisions that overlook critical compliance requirements. Careful judgment is required to balance the urgency of integration with the legal and ethical obligations to all stakeholders. The best professional approach involves a structured and transparent communication strategy that prioritizes compliance with Alabama securities laws and corporate governance principles. This includes establishing clear internal policies for information sharing, ensuring all employees involved in the integration process are fully briefed on their obligations regarding confidential information, and proactively communicating material changes to shareholders and regulatory bodies as required by Alabama law. This approach safeguards against insider trading violations and ensures that the integration process is conducted with integrity and in accordance with the Alabama Securities Act, which governs the issuance and trading of securities within the state. An approach that involves selectively sharing information with key integration teams without a formal, documented policy risks violating Alabama's insider trading regulations. Such selective disclosure could be construed as providing material non-public information to a select group, potentially leading to unfair trading advantages and legal repercussions. Furthermore, failing to provide timely and accurate disclosures to the Alabama Securities Commission or the public, as mandated for significant corporate events, undermines transparency and investor confidence, which are cornerstones of corporate finance law. Another professionally unacceptable approach would be to delay or omit necessary filings with the Alabama Securities Commission regarding the merger's impact on existing securities or the issuance of new ones. This oversight could result in penalties and legal challenges, as Alabama law requires prompt reporting of such material events. The assumption that integration activities are purely internal and do not trigger disclosure obligations under Alabama law is a critical misjudgment. Finally, an approach that focuses solely on operational integration without a parallel focus on legal and regulatory compliance, particularly concerning the handling of financial information and shareholder communications, is fundamentally flawed. This oversight can lead to inadvertent violations of Alabama's corporate finance laws, potentially exposing the merged entity and its officers to significant liability. Professionals should adopt a decision-making framework that begins with a thorough understanding of the applicable Alabama corporate finance law and its implications for post-merger activities. This involves proactive legal counsel, the development of clear integration policies that explicitly address compliance, and a commitment to transparent communication with all relevant parties, including regulatory bodies and shareholders. The integration plan must be viewed not just as an operational exercise, but as a legally regulated process. Question 13. Benchmark analysis indicates that a private company client based in Birmingham, Alabama, is planning to raise capital by offering its common stock to a select group of individuals. The client asserts that these individuals are all experienced investors with significant financial acumen, and that the offering will be limited to no more than 20 purchasers. The client believes this structure automatically qualifies for an exemption from registration under Alabama securities laws. As legal counsel advising this client on Alabama corporate finance law, what is the most prudent course of action? Option A. Advise the client that a thorough review of the specific conditions for private placement exemptions under the Alabama Securities Act is necessary, and if all conditions are not met, registration with the Alabama Securities Commission or reliance on another valid exemption is required. Option B. Advise the client that since the offering is limited to a small number of individuals, it is inherently exempt from registration under Alabama securities laws, regardless of other factors. Option C. Recommend that the client proceed with the offering and obtain written assurances from each investor confirming their sophistication and understanding of the risks involved, which should suffice as an exemption under Alabama law. Option D. Proceed with the offering as planned, assuming that the limited number of sophisticated investors satisfies the requirements for a private placement exemption under Alabama law. The correct answer is A. Advise the client that a thorough review of the specific conditions for private placement exemptions under the Alabama Securities Act is necessary, and if all conditions are not met, registration with the Alabama Securities Commission or reliance on another valid exemption is required. Explanation. This scenario is professionally challenging because it requires a nuanced understanding of Alabama's securities laws, specifically the registration requirements for securities offerings, and the ability to distinguish between exempt and non-exempt transactions. The firm must navigate potential liability under the Alabama Securities Act while advising its client. Careful judgment is required to avoid misinterpreting exemptions and inadvertently engaging in an illegal offering. The correct approach involves a thorough review of the proposed offering against the specific exemption criteria outlined in the Alabama Securities Act. This includes verifying that the offering meets all conditions for a private placement exemption, such as limitations on the number of purchasers, sophistication of investors, and restrictions on general solicitation. If the offering does not clearly fit an available exemption, the firm must advise the client on the necessity of registering the securities with the Alabama Securities Commission. This approach is correct because it prioritizes compliance with the Alabama Securities Act, ensuring the client's offering is conducted legally and avoiding potential penalties, rescission rights for investors, and reputational damage. It demonstrates a commitment to regulatory adherence and client protection. An incorrect approach would be to assume that because the offering is structured as a private placement, it is automatically exempt from registration under Alabama law without further scrutiny. This fails to recognize that Alabama law, like federal law, has specific conditions that must be met for a private placement exemption to apply. Relying on a superficial understanding of private placement without verifying all statutory requirements is a regulatory failure. Another incorrect approach would be to proceed with the offering based solely on the client's assertion that the investors are sophisticated, without independently verifying this status, according to Alabama's legal standards, or ensuring other exemption conditions are met. This approach risks misinterpreting the definition of sophistication and failing to satisfy other critical elements of an exemption, leading to a violation. A further incorrect approach would be to advise the client that no registration is required simply because the securities are being offered to a limited number of individuals, without considering other factors like the manner of the offering or the nature of the purchasers. This overlooks the comprehensive nature of exemption requirements under Alabama law, which often involve multiple conditions beyond just the number of offerees. Professionals should employ a decision-making framework that begins with identifying the relevant jurisdiction's securities laws, in this case, Alabama. They must then meticulously analyze the proposed transaction against the specific provisions of those laws, paying close attention to registration requirements and available exemptions. This involves a detailed review of the facts of the offering and a careful comparison to the statutory and rule-based criteria for each potential exemption. If there is any doubt or ambiguity regarding the applicability of an exemption, the professional course of action is to err on the side of caution and recommend registration, or seek a formal no-action letter from the Alabama Securities Commission. Question 14. The evaluation methodology shows that a financial advisor registered in Alabama has received a formal inquiry from the Alabama Securities Commission regarding a series of investment transactions made on behalf of a client that may involve unregistered securities. The advisor suspects these transactions might have been structured to circumvent registration requirements. What is the most appropriate course of action for the financial advisor to take in response to the Alabama Securities Commission's inquiry? Option A. Recommend that the client immediately transfer all assets to an offshore account to prevent any potential seizure or forfeiture by the Alabama Securities Commission. Option B. Proceed with executing further transactions as previously planned, while preparing a defense strategy to argue that the transactions were not in violation of Alabama securities laws without initially engaging with the Commission. Option C. Advise the client to ignore the inquiry from the Alabama Securities Commission, suggesting that the client has no obligation to respond to state-level investigations. Option D. Immediately cease all further transactions related to the client's portfolio that could be construed as problematic and proactively contact the Alabama Securities Commission to understand the scope of their inquiry and offer full cooperation, including the provision of all requested documentation. The correct answer is D. Immediately cease all further transactions related to the client's portfolio that could be construed as problematic and proactively contact the Alabama Securities Commission to understand the scope of their inquiry and offer full cooperation, including the provision of all requested documentation. Explanation. The evaluation methodology shows that navigating enforcement actions under Alabama corporate finance law requires a nuanced understanding of the Alabama Securities Act and the powers vested in the Alabama Securities Commission. This scenario is professionally challenging because it involves a potential violation of securities laws, requiring the financial advisor to balance their fiduciary duty to their client with the legal obligations imposed by the state. The advisor must act with integrity and transparency, recognizing that failure to do so can result in significant penalties for both the client and themselves. The best approach involves immediately ceasing any further transactions that could be construed as a violation and proactively engaging with the Alabama Securities Commission to understand the nature of the inquiry and cooperate fully. This includes providing all requested documentation and information truthfully and without delay. This approach is correct because it aligns with the principles of full cooperation and good faith required by regulatory bodies. Alabama law, specifically the Alabama Securities Act, empowers the Commission to investigate potential violations and impose sanctions. Proactive engagement demonstrates a commitment to compliance and can mitigate potential penalties. Ethical considerations also dictate that the advisor should not attempt to conceal or obstruct the investigation. An incorrect approach would be to advise the client to ignore the inquiry or to attempt to obscure the nature of the transactions. This would be a direct violation of the advisor's duty to cooperate with regulatory authorities and could lead to severe penalties, including fines, suspension or revocation of licenses, and potential criminal charges. Another incorrect approach would be to advise the client to move assets to avoid potential forfeiture or seizure without understanding the full scope of the Commission's authority and the legal basis for such actions. This could be interpreted as obstruction of justice or aiding in the concealment of illegal activity, further exacerbating the situation and incurring additional penalties under Alabama law. Professionals should approach such situations by first understanding the specific allegations or concerns raised by the regulatory body. They should then consult the relevant Alabama statutes and regulations, particularly the Alabama Securities Act, to grasp the potential legal ramifications. Seeking legal counsel specializing in Alabama securities law is crucial to ensure all actions taken are compliant and in the best interest of both the client and the advisor, while prioritizing transparency and cooperation with the Alabama Securities Commission. Question 15. Process analysis reveals that a publicly traded company headquartered in Birmingham, Alabama, is considering a significant expansion into a new market. This expansion will require substantial capital investment and may impact local employment and the environment. The company's board of directors is debating the extent to which they should actively solicit and incorporate feedback from various stakeholder groups, including employees, local community leaders, and environmental advocacy organizations, in their decision-making process, beyond the legally mandated disclosures to shareholders. Which of the following approaches best reflects responsible corporate finance practice in Alabama, considering the company's fiduciary duties and the broader implications of its expansion? Option A. Focus exclusively on maximizing immediate shareholder returns from the expansion, viewing stakeholder feedback as secondary to financial performance metrics. Option B. Proactively engage with key stakeholders to understand their concerns and perspectives, seeking to integrate their input into the expansion strategy to foster long-term value and mitigate potential risks. Option C. Dismiss stakeholder concerns as outside the scope of corporate finance decisions, as the primary legal obligation is to shareholders. Option D. Conduct superficial consultations with stakeholders solely to fulfill a perceived public relations obligation, without genuine intent to incorporate their feedback into the decision-making process. The correct answer is B. Proactively engage with key stakeholders to understand their concerns and perspectives, seeking to integrate their input into the expansion strategy to foster long-term value and mitigate potential risks. Explanation. This scenario presents a professional challenge because it requires balancing the fiduciary duties owed to shareholders with the broader ethical and practical considerations of stakeholder engagement, particularly when those stakeholders have significant influence over the company's long-term viability. The Alabama corporate finance law exam context necessitates adherence to Alabama's specific legal and ethical standards for corporate governance and stakeholder relations. Careful judgment is required to navigate potential conflicts and ensure sustainable value creation. The best approach involves proactively identifying and engaging with key stakeholders, including employees, customers, and the local community, to understand their concerns and incorporate their perspectives into strategic decision-making. This aligns with the evolving understanding of corporate responsibility under Alabama law, which increasingly recognizes the interconnectedness of corporate success and stakeholder well-being. By fostering open communication and seeking mutually beneficial outcomes, the company can build trust, mitigate risks, and enhance its reputation, ultimately contributing to long-term shareholder value. This proactive engagement is ethically sound as it acknowledges the legitimate interests of all parties affected by the corporation's operations, an approach that prioritizes only immediate shareholder profit maximization, without considering the impact on employees or the community, is professionally unacceptable. This narrow focus can lead to reputational damage, increased regulatory scrutiny, and potential legal challenges, undermining long-term profitability and violating the spirit of responsible corporate citizenship expected under Alabama's legal framework. Another unacceptable approach is to dismiss stakeholder concerns as irrelevant to corporate finance decisions. This demonstrates a failure to recognize the practical realities of business operations, where employee morale, customer loyalty, and community relations directly influence financial performance. Such an attitude can lead to unforeseen operational disruptions and a lack of social license to operate, which are significant financial risks. Finally, an approach that involves superficial engagement with stakeholders, such as merely holding perfunctory meetings without genuine consideration of their input, is also professionally deficient. This can be perceived as disingenuous and may exacerbate stakeholder distrust, leading to more significant challenges down the line. It fails to meet the ethical imperative of good faith engagement and can be detrimental to building sustainable relationships. Professionals should employ a decision-making framework that begins with identifying all relevant stakeholders and assessing their interests and potential impact on the corporation. This should be followed by a thorough analysis of how these stakeholder interests intersect with the company's strategic objectives and financial health. Open and transparent communication channels should be established, and feedback should be genuinely considered and integrated into decision-making processes where feasible and aligned with fiduciary duties. This iterative process ensures that corporate decisions are not only financially sound, but also ethically responsible and conducive to long-term sustainability. Question 16. Strategic planning requires an Alabama-based corporation to consider its obligations under federal securities laws. When preparing its initial public offering, IPO, prospectus, what is the most prudent approach to ensure compliance with the role and oversight of the Securities and Exchange Commission, SEC? Option A. Rely on the advice of experienced investment bankers regarding disclosure content, assuming their familiarity with SEC requirements is sufficient without independent verification of specific SEC pronouncements. Option B. Interpret SEC regulations in a manner that maximizes the company's valuation by presenting information in the most favorable light, even if it means downplaying potential risks or uncertainties that are not explicitly prohibited by law. Option C. Omit certain forward-looking statements that are speculative in nature, believing that the SEC's focus is primarily on historical financial data and that such omissions will not significantly impact investor decision-making. Option D. Diligently prepare all required disclosures in the IPO prospectus, adhering strictly to the Securities Act of 1933 and relevant SEC rules and guidance, and proactively seek clarification from the SEC or qualified legal counsel on any complex or ambiguous disclosure requirements. The correct answer is D. Diligently prepare all required disclosures in the IPO prospectus, adhering strictly to the Securities Act of 1933 and relevant SEC rules and guidance, and proactively seek clarification from the SEC or qualified legal counsel on any complex or ambiguous disclosure requirements. Explanation. This scenario is professionally challenging because it requires navigating the complex regulatory landscape of the U.S. securities markets, specifically concerning the role of the Securities and Exchange Commission, SEC, in overseeing corporate finance activities in Alabama. A thorough understanding of SEC regulations is paramount to ensure compliance and protect investors. The best approach involves proactively engaging with the SEC's established disclosure requirements and seeking guidance when uncertainties arise. This means meticulously preparing all necessary filings, such as registration statements and periodic reports, in accordance with the Securities Act of 1933 and the Securities Exchange Act of 1934, as interpreted by SEC rules and guidance. It also entails understanding the SEC's oversight functions, including examinations and enforcement actions, and maintaining open communication channels with the agency. This proactive and compliant stance minimizes legal and reputational risks for the Alabama-based corporation. An incorrect approach would be to assume that SEC regulations are merely procedural hurdles to be circumvented. This could manifest as intentionally omitting material information from disclosures, believing that such omissions will go unnoticed or are inconsequential. This directly violates the anti-fraud provisions of federal securities laws, such as Section 10b of the Securities Exchange Act of 1934 and Rule 10b-5, which prohibit deceptive or manipulative practices in connection with the purchase or sale of securities. Such an approach risks severe penalties, including fines, disgorgement of profits, and injunctions, as well as significant damage to the company's reputation and investor confidence. Another incorrect approach would be to rely solely on informal advice from industry peers or internal counsel, without verifying its accuracy against official SEC pronouncements, rules, and interpretations. While informal advice can be a starting point, it does not substitute for rigorous adherence to the law. Failure to consult official SEC guidance or seek formal legal counsel when dealing with complex disclosure obligations can lead to unintentional noncompliance, exposing the company to regulatory scrutiny and potential enforcement actions. This demonstrates a lack of due diligence and a disregard for the authoritative nature of SEC regulation. A third incorrect approach would be to interpret SEC regulations narrowly, focusing only on explicit prohibitions and ignoring the spirit of investor protection that underpins federal securities laws. This might involve arguing that if a specific action is not explicitly forbidden, it is permissible, even if it could mislead investors. This overlooks the broad scope of SEC oversight designed to ensure fair and transparent markets. Such a rigid and self-serving interpretation can lead to actions that, while not explicitly outlawed, are nevertheless deemed manipulative or fraudulent by the SEC, resulting in regulatory penalties. Professionals should adopt a decision-making process that prioritizes a deep understanding of SEC regulations, a commitment to transparency and full disclosure, and a willingness to seek expert guidance when necessary. This involves continuous learning about evolving SEC rules and interpretations, fostering a culture of compliance within the organization, and treating SEC oversight as an integral part of responsible corporate governance, rather than an adversarial process. Question 17. System analysis indicates that an Alabama-based technology startup is seeking substantial capital to fuel its rapid expansion. The Chief Financial Officer, CFO, is evaluating two primary financing avenues: issuing new shares of common stock to venture capital firms or securing a significant line of credit from a consortium of banks. Considering the company's current stage of development, its projected revenue growth, and the desire to maintain founder control, which financing strategy would best align with prudent financial management and regulatory compliance under Alabama corporate finance law? Option A. Accept the financing option that offers the quickest infusion of capital, regardless of the long-term financial commitments or the dilution of existing ownership stakes. Option B. Pursue the debt financing option exclusively, focusing solely on obtaining the lowest possible interest rate, without a comprehensive evaluation of the company's ability to meet repayment obligations under adverse conditions. Option C. Opt for equity financing without thoroughly analyzing the extent of ownership dilution and its potential impact on founder control and future strategic decision-making. Option D. Prioritize a financing strategy that involves a detailed assessment of the company's cash flow projections, debt servicing capacity, and the long-term implications of ownership dilution, while ensuring full compliance with Alabama's disclosure and securities regulations. The correct answer is D. Prioritize a financing strategy that involves a detailed assessment of the company's cash flow projections, debt servicing capacity, and the long-term implications of ownership dilution, while ensuring full compliance with Alabama's disclosure and securities regulations. Explanation. Scenario analysis. This scenario presents a professional challenge for the CFO of an Alabama-based technology startup. The company is seeking significant capital to fund its expansion, and the CFO must decide between issuing new equity or taking on debt. This decision has profound implications for the company's financial structure, risk profile, and future obligations, impacting all stakeholders including founders, employees, and potential investors. The challenge lies in balancing the immediate need for funds with long-term financial health and control, all within the specific regulatory environment of Alabama corporate finance law. Careful judgment is required to select the financing method that best aligns with the company's strategic goals and risk tolerance, while adhering to all applicable state regulations. Correct approach analysis. The best professional practice involves a thorough analysis of the company's current financial health, projected cash flows, and the specific terms offered by potential lenders and investors. This includes evaluating the dilution of ownership that equity financing would entail versus the fixed repayment obligations and interest costs associated with debt. For an early-stage technology startup with potentially volatile revenue streams, prioritizing a financing option that preserves ownership control and offers flexibility in repayment, if possible, is often prudent. This approach necessitates understanding the implications of both debt covenants and equity shareholder rights under Alabama law, ensuring the chosen method does not unduly burden the company or violate any corporate governance principles. The CFO should consult with legal counsel specializing in Alabama corporate finance to ensure compliance with all state-specific disclosure requirements and securities regulations. Incorrect approaches analysis. Choosing to solely focus on the lowest stated interest rate for debt without considering the company's ability to service that debt under various economic scenarios is a significant regulatory and ethical failure. Alabama law, like all jurisdictions, expects prudent financial management. Taking on excessive debt that could lead to default, thereby jeopardizing the company's solvency and the investments of all stakeholders, is professionally unacceptable. Similarly, opting for equity financing solely because it avoids immediate repayment obligations, without adequately assessing the impact of significant ownership dilution on founder control and future decision-making, can be detrimental. This overlooks the fiduciary duties owed to existing shareholders and the potential for future governance conflicts. Furthermore, neglecting to conduct due diligence on the terms and conditions of either debt or equity offerings, or failing to ensure full and accurate disclosure as required by Alabama securities laws, constitutes a serious breach of regulatory compliance and professional ethics. Professional reasoning. Professionals facing this decision should employ a structured decision-making framework. First, clearly define the company's capital needs and the strategic objectives for the funding. Second, conduct a comprehensive financial analysis, including stress testing projected cash flows against potential debt repayment schedules and evaluating the long-term impact of equity dilution. Third, engage with legal and financial advisors experienced in Alabama corporate finance law to understand the regulatory landscape, disclosure obligations, and the specific implications of different financing structures. Fourth, compare the risks and benefits of each financing option, considering factors such as control, cost of capital, financial flexibility, and impact on future growth. Finally, select the option that best balances the company's immediate needs with its long-term sustainability and stakeholder interests, ensuring full compliance with all applicable Alabama statutes and regulations. Question 18. System analysis indicates that in an M and a transaction involving an Alabama-based technology firm, the acquiring company's finance team is tasked with determining a fair acquisition price. The target company has a strong intellectual property portfolio, but a history of inconsistent profitability. What valuation approach best aligns with the principles of Alabama corporate finance law and professional ethical standards for this scenario? Option A. Employing a combination of discounted cash flow, DCF, analysis, market comparables, and an asset-based valuation, with a thorough qualitative assessment of the target's intellectual property and management team's expertise to establish a valuation range. Option B. Relying solely on a precedent transaction analysis of similar technology companies, without adjusting for the unique market position and profitability challenges of the target. Option C. Utilizing a valuation model that heavily discounts future earnings due to the target's inconsistent profitability, aiming for a low acquisition price to minimize risk for the acquirer. Option D. Focusing primarily on the target company's historical revenue growth to justify an acquisition price that maximizes immediate shareholder value for the acquirer. Correct answer is A. Employing a combination of discounted cash flow, DCF, analysis, market comparables, and an asset-based valuation, with a thorough qualitative assessment of the target's intellectual property and management team's expertise to establish a valuation range. Explanation. This scenario presents a professional challenge because the valuation of a target company in an M and a transaction directly impacts the interests of multiple stakeholders, including shareholders of both the acquiring and target companies, employees, and potentially the broader community in Alabama. Achieving a fair valuation requires navigating competing interests and adhering to stringent ethical and regulatory standards to ensure transparency and prevent undue advantage. The Alabama Corporate Finance Law Framework, while not dictating specific valuation methodologies, emphasizes fair dealing and the prevention of fraudulent practices in securities transactions. The best approach involves a comprehensive valuation that considers multiple methodologies and triangulates a reasonable range, acknowledging the inherent subjectivity. This approach prioritizes a balanced perspective by incorporating both quantitative financial analysis and qualitative factors that contribute to the target company's intrinsic value and future prospects. It aligns with the spirit of Alabama corporate finance law by promoting a fair and informed transaction, minimizing the risk of misrepresentation or exploitation of any stakeholder group. This method fosters trust and ensures that the transaction price reflects a reasonable assessment of the company's worth, considering its assets, earnings potential, market position, and strategic fit. An approach that solely focuses on maximizing the immediate return for the acquiring company's shareholders, without adequately considering the fair value for the target company's shareholders, is professionally unacceptable. This could lead to a situation where the acquisition price is perceived as predatory or unfair, potentially violating principles of good corporate governance and fair dealing inherent in Alabama's regulatory environment. Such a narrow focus risks overlooking crucial qualitative factors or future synergies that would justify a higher valuation for the target, thereby failing to uphold the fiduciary duties owed to all parties involved in the transaction. Another professionally unacceptable approach is to rely exclusively on a single valuation methodology, especially one that is known to be overly optimistic or pessimistic without robust justification. This can create a skewed perception of value and may not withstand scrutiny from regulatory bodies or dissenting shareholders. Alabama law expects diligence and a reasoned basis for valuations presented in M and a context. Finally, an approach that prioritizes speed and convenience over thoroughness, perhaps by using readily available but less rigorous valuation estimates, is also problematic. This can lead to an inaccurate valuation that does not reflect the true economic reality of the target company, potentially resulting in a transaction that is detrimental to one or more stakeholder groups and could be challenged under Alabama's corporate finance regulations. Professionals should employ a decision-making framework that begins with understanding the specific context of the M and a deal, including the motivations of all parties. This should be followed by selecting and applying a range of appropriate valuation methodologies, critically assessing the assumptions underpinning each, and then synthesizing the results into a defensible valuation range. Transparency in the valuation process and clear communication of the rationale to all relevant stakeholders are paramount, ensuring compliance with the ethical obligations and regulatory expectations under Alabama corporate finance law. Question 19. System analysis indicates that a publicly traded Alabama-based corporation is considering a significant acquisition. The proposed transaction is expected to result in substantial cost savings through workforce reductions and the consolidation of operations, which would likely enhance shareholder value in the short to medium term. However, these changes would also lead to significant job losses in the local community where the company is headquartered and has a long-standing presence. What is the most ethically and legally sound approach for the board of directors to take in evaluating this acquisition under Alabama corporate finance law? Option A. Negotiate the acquisition terms in a manner that primarily benefits a controlling block of shareholders, ensuring their financial interests are secured above all other considerations, and providing minimal disclosure to the broader shareholder base. Option B. Prioritize maximizing immediate shareholder returns by approving the acquisition based solely on projected cost savings and enhanced earnings per share, without significant consideration for employee or community impact. Option C. Proceed with the acquisition based on preliminary financial analyses that suggest positive shareholder outcomes, deferring detailed impact studies on employees and the community until after the transaction is finalized. Option D. Conduct a comprehensive assessment of the acquisition's impact on all key stakeholders, including shareholders, employees, and the local community, while ensuring full compliance with Alabama's disclosure and fiduciary duty requirements. The correct answer is D. Conduct a comprehensive assessment of the acquisition's impact on all key stakeholders, including shareholders, employees, and the local community, while ensuring full compliance with Alabama's disclosure and fiduciary duty requirements. Explanation: this scenario is professionally challenging because it requires balancing the fiduciary duties owed to shareholders with the potential impact on other stakeholders, such as employees and the community, during a significant corporate transaction. The Alabama corporate finance law, while primarily focused on shareholder value, also implicitly requires adherence to ethical business practices and disclosure obligations that can affect all parties involved in a merger or acquisition. Careful judgment is required to ensure compliance with Alabama law and to maintain the company's reputation and long-term viability. The best professional approach involves a comprehensive assessment of the merger's impact on all key stakeholders, including a thorough review of the financial implications for shareholders and an evaluation of potential operational changes that could affect employees and the local community. This approach prioritizes transparency and adherence to Alabama's corporate finance regulations by ensuring that all material information relevant to the transaction is considered and appropriately disclosed, thereby fulfilling fiduciary duties to shareholders while also acknowledging broader corporate responsibilities. This aligns with the spirit of Alabama corporate law, which expects directors and officers to act in good faith and with due care, considering the overall health and sustainability of the enterprise. An approach that solely focuses on maximizing immediate shareholder returns without considering the long-term consequences for employees or the community is ethically problematic and potentially violates the duty of care owed by directors and officers. While shareholder value is paramount, Alabama law does not permit actions that are demonstrably detrimental to the company's long-term prospects or that involve misleading disclosures. Another unacceptable approach would be to proceed with the merger based on incomplete or misleading financial projections, even if those projections appear favorable in the short term. This would constitute a failure to exercise due diligence and could lead to violations of Alabama's securities laws and disclosure requirements, exposing the company and its leadership to legal and reputational risks. Finally, an approach that prioritizes the interests of a select group of shareholders over the broader shareholder base, or that fails to adequately inform all shareholders about the material terms and risks of the merger, would be a breach of fiduciary duty and a violation of Alabama corporate law principles. Professionals should employ a decision-making framework that begins with a clear understanding of the legal and ethical obligations under Alabama corporate finance law. This involves identifying all relevant stakeholders, conducting thorough due diligence on the proposed transaction, assessing both financial and non-financial impacts, ensuring full and fair disclosure, and acting in a manner that promotes the long-term interests of the corporation and its shareholders, while also considering the broader impact on the business ecosystem. Question 20. What factors determine the fair market value of a target company in an acquisition scenario governed by Alabama corporate finance law when considering the financial implications for selling shareholders, the acquiring entity's long-term viability, and potential impacts on employees and the local community? Option A. A weighted average of discounted cash flow (DCF) analysis, comparable company analysis (CCA), precedent transaction analysis (TA), adjusted for specific company and industry factors, and considering broader stakeholder impacts. Option B. A valuation based on a quick assessment of the target's tangible assets, prioritizing speed and minimizing due diligence costs. Option C. The highest price achievable solely based on the immediate liquidity needs of the selling shareholders, irrespective of the acquiring entity's future financial capacity. Option D. A valuation derived exclusively from the market capitalization of publicly traded companies with similar business models, without further adjustments. The correct answer is A. A weighted average of discounted cash flow (DCF) analysis, comparable company analysis (CCA), and precedent transaction analysis (TA), adjusted for specific company and industry factors, and considering broader stakeholder impacts. Explanation. This scenario is professionally challenging because it requires balancing the fiduciary duties owed to different stakeholder groups within the context of an acquisition, while strictly adhering to Alabama corporate finance law. The complexity arises from potential conflicts of interest and the need to ensure fair valuation and process, which are central to the legal framework governing and transactions in Alabama. Careful judgment is required to navigate these competing interests and legal obligations. The best approach involves a comprehensive valuation that considers all relevant factors and stakeholders, using a methodology that is transparent and defensible under Alabama law. This includes performing a discounted cash flow (DCF) analysis, a comparable company analysis (CCA), and a precedent transaction analysis (TA), weighting them appropriately based on the specific circumstances of the target company and the industry. The resulting valuation range should then be used to negotiate a price that is fair to both the selling shareholders and the acquiring entity, while also considering the impact on employees and the community, as these broader considerations can influence the long-term success and ethical standing of the transaction under Alabama's corporate governance principles. This approach ensures that the transaction is not only legally compliant, but also ethically sound and maximizes long-term value creation, an approach that solely focuses on maximizing the immediate cash payout for the selling shareholders, without adequately considering the long-term implications for the acquiring company's financial stability or the potential impact on employee retention and community relations, would be professionally unacceptable. This could lead to a transaction that, while appearing beneficial in the short term, creates future liabilities or reputational damage, potentially violating the spirit of Alabama's corporate finance laws, which aim for sustainable business practices. Another unacceptable approach would be to rely on a single valuation methodology, such as only using a CCA, without cross-referencing with other methods like DCF or PTA. This narrow focus can lead to a skewed valuation, failing to capture the full economic reality of the target company, and potentially resulting in an unfair price for either party, which could be challenged under Alabama's fair dealing statutes. Finally, an approach that prioritizes speed and convenience over thorough due diligence and a robust valuation process would be detrimental. Rushing the process without proper investigation into the target's financial health, legal standing, and operational risks could expose the acquiring entity to unforeseen liabilities, contravening the prudent business judgment rule often applied in Alabama corporate law. Professionals should employ a structured decision-making process that begins with a clear understanding of the legal and ethical obligations under Alabama corporate finance law. This involves identifying all relevant stakeholders and their interests, conducting thorough due diligence, employing multiple valuation methodologies to establish a fair value range, and engaging in transparent negotiation. Documenting the rationale behind valuation decisions and the negotiation process is crucial for demonstrating compliance and good faith.